The difference between the affirmative versus defensive process when you have an asylum case is that the affirmative case is before USCIS, while with the defensive asylum, you're actually in court. Now, with the proposed new policy change, a USCIS officer could review your file and make a determination based on the paperwork filed that your case should be referred to the immigration court versus giving you the opportunity to sit and speak to a USCIS officer. So if you have a pending asylum case before USCIS, now is not the time to sit and wait around. You want to ensure that you're prepared and you know what can happen, because it could be a case where your case is referred to the immigration court and you'll have to go before an immigration judge to fight your asylum case. What I believe is that most of the cases that will be referred will be cases that were filed outside of the 1 year period, because outside of the 1 year period it's an automatic ban. There are exceptions, so if you don't fall within that exceptions, I'm assuming that your case may be one of those cases that will be referred out. And if they look at your case and say, for instance, it was filed without evidence, your case could be one of those that will be referred to immigration court. So we're still watching to see how this will play out, but this will impact a lot of people. Right now, they did send out a report. They have around 1.4 million cases in the affirmative process. So a lot of those cases will be referred to immigration, to an immigration judge. So if this is you, make sure you're reaching out, and also ensure that they do have your updated address, because when they send out those notices to appear, you want to make sure that you're getting a copy. Because if you don't get a copy of your notice to appear and you fail to appear for your removal or your first hearing before that judge, you could be issued an order of deportation.